The following is a production of KYNE TV in cooperation with UNO Television. Consider This with Carol Schrader, a news and informational program recorded on the campus of the University of Nebraska at Omaha. Here is your host, Carol Schrader.
Hello and welcome to the Milo Bale Student Center at the University of Nebraska at Omaha. Consider this. There is a rift between the African American community and the mayor, or at least the administration, and sort of the city of Omaha in general. Consider the fact that we might need some mediation. If you don't know what that is, at least in sort of the legal or common practice parlance, we're going to talk about it today. With me is John Miller, who is a lawyer in practice for, what, 26 years, you said?
26 years, 26 long years.
And a former Omaha City Councilman. And he is in practice also as a mediator. And with us today, one of the first mediators I ever interviewed is Pat Lamberty, who, in terms of the hypothesis we're working under, is a lawyer, a mediator, and I don't normally do this husband-wife kind of thing, but married to a recent candidate for mayor of Omaha. So I think that makes an interesting mix, a former city official. Certainly someone close to someone that wanted to be one. We have a situation in Omaha. I don't know how bad it is, John, Pat, but it just dawned on me that we need some mediation, some form of mediation. In terms of what you folks do, could we mediate a bubbling, brewing problem in Omaha, or a perception of problems, or whatever it is we have?
I'm not familiar, of course, with the specific issues that is causing the rift between the African American community and the mayor. But in general, most conflicts can be mediatable, certainly public policy conflicts. We are currently mediating conflicts at the international level between countries. Certainly Bosnia is an example. When the Soviet Union broke up, now Russia, there was some mediation that went on. We sent mediators over there. Internationally, companies are mediating with each other. One company from Romania will mediate a company in Austria. So it's clear to me that yes, it's possible to mediate and could mediate the kind of a dispute that's going on in Omaha. It's not easy when you've got a public policy case because there's normally a lot of factions involved, and you need all parties represented at the table with the decision maker present.
We don't even know what parties we really, I mean, we think there's two sides, but it seems like, just using this as sort of a hypothetical.
There
John.
are as many sides as there are different perceptions. My experience with mediation and my experience, as a litigation lawyer was that nobody enters into a conflict with the feeling in their heart of hearts that they are being unfair and that they are on the wrong side. Everybody's perception is that, I'm being fair about this and I see this clearly. And if I could just get you to see this through my eyes, we could get this matter resolved. But you have two people, maybe three people, who have different perceptions, who believe in their heart of hearts that they have the accurate perception. And so in mediation, we bring in a third or fourth party neutral, like Pat or myself, to sit down and explore those and examine those perceptions with the hope that maybe I can bring you to a better understanding of my perception and my rationale, and you can bring me to a better understanding of your perception and your rationale, and the end result, being a healing and a resolution of the dispute that we are both satisfied with.
What's important in this is that the parties are present together and they talk about what they're particularly concerned about or what their particular interests are, and that they hear each other. And the mediator then helps them hear each other and then draws out what the particular issues are.
Well, just in this particular case, and it's not like a suit is filed and someone says they were wronged, and there's some basic facts, and there might be some gray areas around some of those facts, but basically the wronger and the wrongee, or the alleged wronger and the wrongee, I know there's more proper terms, know what is in the middle, what the issue is, more or less. Right now, in the city of Omaha, we're hearing a lot of anecdotal stuff, and we think the issue is a rift or a prejudice in practice or whatever, but everybody comes up with something different. I mean, how if we solve this by mediation or otherwise, how do we boil the issues down and get them on the table?
That's what the trained mediator does, and the parties come and say what they're concerned about, and the mediator listens very carefully, and the mediator draws out then what the issues are and develops an agenda. And then the parties together, with the assistance of the mediator, work out possible resolutions, often creative resolutions.
John, you've lived here a long time. You know kind of at least what your particular perception of what's happening in the Omaha area, what people are feeling. I know you've talked to a lot of people when you have time, when you're not mediating. Could we come up with a list of issues? Could trained people, whether they be, whoever?
I think yes. I think that, I think our public leaders, our public officials, need to think perhaps of themselves as mediators rather than politicians. I think that any dispute, the basis for a dispute usually stems from a misunderstanding. People believe that their understanding is the correct, understanding. People think they have the right perception. And you need to examine those perceptions. You need to examine those, understandings, misunderstandings that we have. And I think that, first of all, you need to have a setting. Mediation creates a safe, secure setting for people to sit down. We don't conduct mediations on a street corner with baseball bats in our hands. We conduct them in a safe setting where people understand that nothing will happen here that you, the parties, don't voluntarily agree to. In the process of mediation, you have more than a vote. You have veto power.
Kind of the Security Council kind of thing.
And mediation is a confidential process. There's no reason that anybody need be concerned about holding anything back. And my experience is that when people, for example, or groups of people have resentments towards one another, once those resentments are articulated to each other, they cease to become resentments. They may be other things, but the resentment disappears. Mediation, in my view, is not only a conciliatory, it's a healing process. The kind of mediation I do is a little bit different than what Pat does. All of the mediations I'm involved in are mediations that are in or are about to be in litigation. I'm called to mediate. I'm called by lawyers and insurance companies and companies that have a dispute.
The next step would be a courtroom if you don't, the suit has been filed or whatever. And
that's right.
And this is like one last
and
kind of...
positions are pretty hardened by that time. People have their heels pretty well dug in, but it's a miraculous process. I was involved in over 150 lawsuits last year, probably 85% of which were resolved at the time of the mediation, to the satisfaction of both sides. In the courtroom, one side always leaves the arena with the sense that they've not been dealt with fairly. In mediation, both sides leave the process with the sense that they've been dealt with fairly, because if they don't feel they've been dealt with fairly, you won't have a resolution of the matter.
I agree with John. I too, most all of my mediations are in litigation. And going to court, there's a winner and there's a loser. And there's rarely a dispute where it's all right and all wrong. And nobody feels good about somebody winning and somebody losing, or at least the person that lost it. And so the advantage of mediation is that you try to carve out resolutions that address both parties' interests. And sometimes a part of it is just saying, you're right and I'm sorry about that. And it's a healing process just when those words come out.
The format in mediation, the mediations that I conduct, I bring you and Pat who have a dispute together. But then I separate you. And I let you vent all of your frustration, all of your anger, all of your pain with Pat. to me.
And then do you try to focus on what the things are?
I let you vent all of
Vent
that
first.
to me. Vent first, out of Pat's presence. But then I can go to Pat, and in very gentle terms, I can explain to her, you know, your feelings in such a manner that if you were to vent your feelings directly to her, she might get up and
Yeah,
walk
I can use
out.
some pretty wild language to say what I would do to her and how she would feel about it.
I can couch your wild language, you know, your rough tongue, in very gentle tones to her. And what I hear usually is, I had no idea that Carol felt that way, and you know, and then she can vent to me, and I shuttle back and forth. The mediator can defuse, you know, a volatile situation, where if the two of you were face to face, the sparks might fly. But through the mediator, you vent, you know, I couch that in gentle terms to her. She shares with me her frustrations and feelings about you. I bring that back to you, and at the appropriate time, you know, I bring you both back together again, and hopefully,
we're ready for
and
that.
a lot of times what happens, you embrace and say to one another, I had no idea you felt that way, you know?
Mediations can be done different ways depending upon the circumstance and the type of mediation that it is. Certainly the way that John is talking about is a very typical way that business mediations are conducted or personal injury mediations are conducted. It's not always the way that we conduct mediations, for instance, in family law or in neighborhood disputes. In a mediation where the parties need to have an ongoing relationship. In other words, when the mediation is done, they can go their own ways and never see each other again is one thing. But if they're going to have an ongoing relationship where they need to be able to work together in the future, then you tend to do more of the mediation with the parties together as opposed to separating them. You certainly start together. You might even permit some venting together, and only if you think that it's so hostile and so angry you separate them, but then you may bring them back together again. Once again, what you want to do there is begin to establish lines of communication for an ongoing relationship so that there's different types of mediation depending upon the type of case that it is.
Okay, I don't want to continue with this city of Omaha analogy too much because I want to get into some of the different, I know, but I do want to say, and I know that you've, you know, together we have all lived here a long time and we have a great fondness for this community. Are you at least not concerned that some of the kinds of values that come out of a mediatory process can be found and will be found here?
Well, I would certainly hope so. I think we have people in our community, we have leaders, we have ministers, and priests and rabbis, you know, who serve as mediators, you know. They help to focus the attention of their flock, if you will, on the conflict that takes place and help defuse that, let people vent. We have, you know, politicians who are, you know, you and I were talking earlier, long before I, you know, heard the term mediation as a member of the city council, I thought of myself as a mediator.
So did I. As a reporter, I thought you were. But it has to be present, the will.
In order to successfully mediate, all the parties have to agree to mediate. That's the first thing. And the second part is that the decision makers have to be at the table. The party that can make the decision. So when you're talking about a public policy mediation, you are normally talking about a number of parties, and you have to have either an authorized representative or the person there that can make the decision. And there has to be an agreement to do that, and a real willingness to work hard. Mediation is not easy.
Is there always a sense in mediation that there has to be concession as opposed to understanding, and then maybe, I mean, what are the elements? Does there always have to be concession? Does there always have to be reparation? Does there always have to be, in the case of the city, obviously there would have to be some, does there even have to be admission? I mean, because you have some real egos involved in some people, as you say, who come from the point of view that they haven't done anything wrong or they have been wrong. I mean, what are some of the kind of elements that you need? Do I have to, is the mayor saying, oh, I have to go and say I've done something wrong, so I'm not going to go? Or maybe you're in a chamber, Lord help me, I can't imagine Ernie coming. I'd sure like to see him come to some table.
I can't, of course, I mean, I don't have a clue about what the issues are with respect to the mayor and the African American community.
Yeah, here we are sitting here, three white people. You know, I mean,
no, and every mediation differs in terms of what the issues are and how it's resolved.
The need to be right in all of us is a powerful,
Oh, yeah.
strong drive and a strong need. It really is. And that's one of the things that a mediator, you know, has to address. People need to feel that, you know, that they are right. I was involved in one...
before you go on, does it mean that somebody else has to be wrong?
No, no. I was involved in one civil mediation, involved a lawsuit for damages. We're talking about money here. During the course of the mediation, the injured party, you know, it was a very painful mediation, a lot of tears, a lot of pain. And this lady said, she said, you know, I don't want any of the other party's money. I said, what is it you want? She said, what I really want is an apology. What she really wanted was an apology. During the course of that mediation, I went to the other side and I said, you know, you apparently didn't hear what this person was telling you. A lot of pain there. And I took that party's pain and, you know, illustrated it for the defendant in the lawsuit. Defendant said, I had no idea. You know, apparently I wasn't listening. These are people that had a relationship, professional relationship. And a real healing took place, you know. An apology, you know, was initially given in writing. One party didn't want it face to face, but before we were finished, they came face to face, and a real healing took place. The matter was resolved, and a lawsuit was dismissed, and no money changed hands. That doesn't happen very often, but that's the power of the process. It's a miraculous process.
Sometimes, I mean, obviously money is the issue, but oftentimes, particularly in mediations involving family, which is a way that mediation is used quite a bit these days, the issues go far beyond family. It's parents sitting down and saying, okay, how are we going to parent these children once we're no longer living together? And they can fashion out resolutions, develop creative resolutions that they couldn't possibly get in a courtroom, because a judge doesn't have the amount of time that it takes to fashion out those kind of creative resolutions. And so it's a way that the parties control what's going to happen in the future, and a way of reaching an agreement where everybody wins. And that's why we like to call mediation a win-win.
Well, where did the word come from? I'm thinking in the middle somewhere, some Latin,
the
like median.
In the middle, I think that's probably right.
That there at least some meeting somewhere close maybe to the middle. Let's get into some.
It probably have to do with the conciliatory nature of the media.
I don't. Mediation is that a relatively new tool in jurisprudence as we know it, using it in courts and legal cases and things?
No.
Nope.
It's all of mankind.
I just didn't know. I just sort of heard of it several years ago or so.
It's been formally introduced within the last 20 to 30 years around the country. In Nebraska, it probably started initially with the Douglas County Conciliation Court, and then was actively used in the late 80s in northeast Nebraska when the bankers and the farmers got into farm foreclosure suits.
Oh, during the farm crisis.
Yes, when the banker and the farmer were sitting next door to each other in church, and needed again to have an ongoing future relationship where the farmer didn't lose the family farm and the bank figured out a way to collect its money. And so that's where mediation really got a strong foothold in Nebraska. And then it was formally adopted into our statutes by way of the setting up a state office of dispute resolution in 1991. And then carried a little further in Nebraska with the adoption of the legislation passed that went into effect September of 1994 on the Parenting Act. So it's being used quite a bit these days in family law.
Where are you in litigation where you do mostly where there is at least a business involved, or like I'm suing a business or I'm suing somebody else that
I do a lot of personal injury, automobile accidents, products liability, medical malpractice, that kind of litigation. Some business litigation, dissolution of partnerships where there's, you know, a dispute.
And lawyers are some of the worst.
Yeah, well,
no, I'm just teasing.
no, but well, that's
you gave
true.
me a shot.
That's true. You know, mediation is everything that litigation is not. Mediation is quick, it's inexpensive, and it works. Litigation is anything but quick. It has become incredibly expensive, and it never works to the satisfaction of one side. One side always leaves the courtroom feeling that the system didn't work for them, that somehow they, you know, were not able to tell their story in such a fashion that the judge and jury understood it. Sometimes both sides leave the courtroom with a real sense of frustration. People don't leave mediation angry, bitter, or frustrated. They leave there with a sense of resolution, a sense of closure, a sense that they've been dealt with fairly because they are part of the process. They have a vote in the courtroom. The parties to a dispute, the lawyers, don't have a vote. You turn your dispute over to a group of strangers whom you've never met before, will never see again. You turn it over to a judge who is so busy, so overworked, he can't put the time into the file that the file perhaps requires. The people best able to mediate a dispute are the parties to the dispute and their representatives.
So,
I was going to add that oftentimes parties feel like they didn't get to say what they wanted to say in court because we attorneys control what goes in, what goes
No.
Just
before
answer
the
that
judge.
yes or no.
no.
Just yes or no.
I'll say no.
And parties want to have their say. They have lots on their, I mean, John talked about venting, and venting is a very important part of the mediation
I just
process.
watched my one of 3 in a row back-to-back Law and Orders the other night, and that always strikes me when they get them on the stand. Just answer the question.
That's right.
And there is a lot of, I mean, even just watching a drama, there's like, what, I mean, we all are like that, and it has to
Yes.
be an efficient process in a courtroom.
Yes.
And it has to be germane.
But what's fascinating to me as a lawyer who was a litigation lawyer for 26 years of his life and grew very tired of it, is through the process of mediation I have discovered, I would say that 99% of the litigants that I'm involved with as a mediator don't want to go to court. They want a resolution of the dispute. A majority of the lawyers who are litigation lawyers and make their living in the courtroom don't really want to walk into that courtroom.
I'll give you a personal example very quickly. I was in a
Yes.
car accident. I had some damage to my face. I was in TV full time. I was concerned, and I wanted a small amount of money just to put away in case I had to have some surgery or something down the line. But then you have to up the amount because you have a third taken off. I'm not blaming lawyers, and then it's totally out of my control. They call you once in a while and tell you where they're at. And it always bothered me that the guy that hit me never said he was sorry.
That's a great case
Always.
for mediation.
And I just wanted, like, you know, maybe $4,000 or $5,000 to put in the bank, let it grow if I needed to have some surgery. That was it. So, but why didn't somebody say when I walked in, and I'm not mad at my lawyer, why didn't they say, these are some options that we have?
Litigation lawyers don't think of themselves as healers or mediators. They think of themselves as warriors.
I think that testosterone sometimes in the office has a lot to
We also have an educational process, a long way to go yet with respect to educating both the public and attorneys.
Do they must teach it in law school now. So I mean,
well, they might
they're
now.
They're just beginning. But the
Yes.
law, you know, it took me many, many years. I didn't discover till maybe the last 2 years of my practice that the law is a healing profession. Lawyers are called to be healers. People will share things with their lawyer that they won't share with their priest, minister, or rabbi. They will share things with their lawyer that they won't share with their spouse. You know, lawyers are invited time and time again, you know, to be healers. They have great opportunities. The problem is we lawyers haven't discovered that. We are just now on the threshold of beginning to discover that the law is in fact a healing profession. We are called to be healers, not warriors.
Plus, it can be an educating profession if you know. So you say it's not a mainstay of
No.
law education?
Well, it is being taught now at, for instance, Creighton Law School and a number of law schools around the country, but that's a relatively new development. And being taught a course is not the same as experiencing it. I think lawyers actually have to experience it to figure out how they fit into the process. Without knowing that, they're concerned that, you know, they're not going to be a part of it and won't have it, and they are a part
They
of it.
studied all those court cases for nothing, you know. But it's not for nothing, really.
I say to the lawyers in the mediations that I conduct, you know, I say, I want you to leave your lawyerliness out in the parking lot. This is a gentle healing process that we are about, and anything you as a lawyer have to say to the other side, you know, I want you to say it in a gentle sharing of information mode as opposed to an adversarial mode. I want to get away from the finger pointing. And I find that, you know, once I set those boundaries, lawyers are very, very gentle with one another. But it's difficult for a lawyer to take off that coat of, you know, armor, set his adversary nature aside. But mediation calls lawyers to do that.
Yeah, I get this picture of the knights on the horse with the lances, you know, and of course, what do? You know, if you've ever seen jousting.
See, I have a picture of, you know, the orangutan beating its chest.
See, what I was talking about.
Not all cases also have lawyers involved.
Yeah, and
Right.
not all of them come out all right. I mean, this is not a perfect world. We have a couple of minutes. I want to know, what other areas are we seeing mediation in more? I know it's even being done with students in school. I mean, what are the places where we can bring it into our life so that we are used to this process?
Well, regularly right now, it's certainly being done in small claims court in Douglas County. Every small claims court case is offered mediation. It's oftentimes used in landlord-tenant disputes or in neighborhood disputes. Certainly in the area of family law and in personal injury litigation that John is familiar with, it's being used quite a bit. Nationally and internationally, it's being done with respect to, you know, country conflicts and environmental law.
Well, let's pray for a little
Disputes
mediation
between the
in
baseball
Mideast.
players and the baseball owners.
Well, a
get
labor
mediated.
for a long time has
Sure.
used.
Yes,
sure.
Some of my best
Yes.
friends are federal mediators.
Yes.
Well, so I guess that you should, if you go into a lawyer and they haven't heard of it or don't want to even talk about it, maybe that's not a good sign.
I think the client can go in and say, you know, I would really like to mediate this case. Can you suggest
Let's
to me
try
a
it.
mediator?
Well, thank you very much. John
Thank you
Miller,
for
Pat
having us.
Lamberty. We could
Thank
go
you.
on and on. Think mediation. All right? Mayor? Anybody? Thank you for joining us.
Thank you.